I want to mention that indeed this first amendment that we're considering today is a historic moment for our country. Mr. Speaker, the manner in which we process this as a House, Mr. Speaker, the Hansard of these deliberations, the reports of the committee, the discussions, the public participation, Mr. Speaker, will create a very important precedent for any future amendments to our constitution by way of popular initiative, Mr. Speaker. Mr. Speaker, we know historically there have been many opportunities, starting from 1963, where we had legal notice 718 of 1963, the Kenya Independence Order in Council, and many other opportunities every year, 64, 65, all the way until we culminated in what we have today, Mr. Speaker, as the Constitution of Kenya 2010. Subsequently, Mr. Speaker, this then becomes the first amendment of our Constitution. And Mr. Speaker, the need has been explained very well. I had the mover, I had the chair of the committee, and many members who spoke to really the need for building bridges and building cohesion in our country and creating an equitable society, Mr. Speaker. Mr. Speaker, before going into the issues of the minority report, Mr. Speaker, let me just say broadly that I had earlier, and if I'm not wrong, I think my chair said that there's a matter of two bills.
Order, senators. There's some gatherings. Order, Senator from Marakwet and Kajiado. Let's listen to. It's important. People listen to you when you talked. So let's also listen to them. Yes, Senator Sakaja.
Yeah, thereabout. So, Mr. Speaker, I'm saying that I think one thing that we're emphatic about in the committee, and I'm glad my chair is here, was the issue of the bill. That there is one Constitution of Kenya Amendment Bill. There were no two bills. Mr. Speaker, what we found was that there were copies of the bill that had errors. And that is something that is at the discretion of this House to resolve. And Mr. Speaker, I've heard Senator Wambua saying that we can amend to sort out those errors, Mr. Speaker. And the question that arises then, and we consider this very well in our committee, is then what the threshold would be. Mr. Speaker, Standing Order 162 of our standing orders, Mr. Speaker.
Senator Cherargei, what's your point of order? Okay, there's a point of order there.
Mr. Speaker, I wouldn't want to interrupt Senator Sakaja, but I've interrupted him already. Mr. Speaker, is it in order that we can get a copy of the minority report? And because I can't see here, and number two, Mr. Speaker, I have not even finished requesting. Number two is that I have noticed the people who signed the minority report, majority of them are members of National Assembly. So I wanted to seek direction because I only saw Senator Sakaja and a few members of National Assembly who signed this report. So it is important that those clarifications are given. Thank you, Speaker.
Thank you, Mr.
There's another point of order,
Mr. Speaker.
Sakaja has another point of order.
Mr. Speaker, is it in order for Senator Sakaja to mislead this House, Mr. Speaker, by saying that the copy of the bill that came to this House had some few errors, but he's saying that it's a copy. Mr. Speaker, if you take a document like this standing orders to a photocopier, there's no way a photocopier will insert errors, Mr. Speaker. And so, Mr. Speaker, is in order to try to downplay a very weighty submission by a senior counsel, Okongo Omogeni, who has practiced law for many years, and who, Mr. Speaker, is a senior counsel and chair of the Legal Affairs Committee, who ably submitted that, Mr. Speaker, there is a problem in the bill that came to this House that required to be corrected, and there are glaring errors. Is it in order, Mr. Speaker, to mislead the House?
Senator Sakaja.
Thank you, Chair. I'm in order to give my opinion, and not just that, the emphatic resolution of the committee, and Senator Mogeni can confirm, the committee resolved, including at the press conference, that there is one bill. Mr. Speaker, allowing a discussion of different bills will bring first the issue of whether this is properly before us, because if 32 or 34 county assemblies looked at one bill and other county assemblies looked at another bill, it should not even be at this time. So what I'm saying is the deliberations of the committee found that there is one bill, but certain copies had errors. So yes, he's a senior counsel, but not in lexicography, Mr. Speaker. He's a senior counsel in law, but that was the finding of the committee, and it is in the report, Mr. Speaker. But Mr. Speaker, that is not the essence of my minority report. And to Senator Cherargei, who has been a chair of a committee, even one member is a minority. And Mr. Speaker, at the time of signing and compiling my minority report, 6 members had signed on, now there are 10 members. And this morning, the co-chair of Senator Mogeni, Honorable Muturi Kigano, in the National Assembly, has actually said he supports the minority view. And he has mentioned that in the National Assembly. But that is neither here nor there, Mr. Speaker. Whether people disown a report or not, I think the issues that we're discussing are of utmost importance to us. Mr. Speaker, the first ground on which I took a different view as I go into the substance of the minority report, Mr. Speaker, and for the information of members, Senator Cherargei, if you look at our standing orders, when a report is tabled,
what's your point of order?
The minority.
What's your point of order, Senator?
Yes, Chair, I seek your direction to the
I
point.
gave him first, eh? Okay, yeah.
Yes, thank you, Chair. Thank you, Mr. Speaker. Mr. Speaker, sir, the Honorable Senator for Nairobi has said a very strong point that we seek your directions on. He has said that some members signed both the minority and the majority report. Mr. Speaker, is that a legal and a correct parliamentary procedure where you have members who are signing minority, majority, which reports conflict? Thank you.
What's your point of order, Senator Wetangula? Order, Senator Murkomen.
Wapi sanitizer?
Sanitizer, yeah.
It hasn't been used. Mr. Speaker, I regret interfering with the thought process of my distinguished nephew, who is not even listening. Mr. Speaker, yesterday, a member raised an issue on the floor, and you directed, and rightly so, as to whether we are debating the Constitution of Kenya Amendment Bill, was it today, or the report of the committee. And it was, I think it was Rose Nyamunga, yes. And you ruled very clearly, and rightly so, both in law and in fact, that we are debating the Constitution of Kenya Amendment Bill. This House is not debating any report, majority or minority. The purpose of the report, you can only make reference to it in relation to clauses of the bill. You cannot start debating a matter that is not before the House. Reports of committees, Mr. Speaker, through precedents, usage, and the standing orders themselves on bills inform and assist the bill in a manner in which it's debated, and if it's an amendable bill, then the report of the committee can propose amendments to the bill. But we cannot, in the process of debating the bill, then cleverly disguise the debate and start debating a report of the committee that is not before the House.
Chair.
Why don't we let him proceed? But that's the correct position.
Chair.
Senator Murkomen, what
Chair,
else?
if members are patient.
Yeah, okay,
it is not lost.
Okay, it's a point of.
Mr. Speaker, Senator Wetangula has raised a very, very fundamental issue, Mr. Speaker, and I had not even seen it from that angle. The fundamental question here is that we are neither discussing the majority or minority report. Yes, Mr. Speaker, Senator Sakaja has risen under the pretext, ostensibly, Mr. Speaker, to move a minority report. Mr. Speaker, there was no majority report that was moved. What was moved was the bill. And all the debaters in the chambers, Mr. Speaker, are debating based on after reading the report as a whole, together with the dissenting or additional arguments made by Senator Sakaja in the committee. The Speaker, if you allow this method to proceed, I foresee danger in future in terms of procedure. Members will be going to their committees, Mr. Speaker, during making of bills. Then when they come back, they agree with the bills, and 2 or 3 people don't agree with a few things. They write a report, and when they come to the chambers here, the move of the bill, whether the majority leader or the leader of the committee or the chair of the committee will move the bill, and then, Mr. Speaker, some other person will allocate themselves 1 hour in the pretext, Mr. Speaker, that they have a minority report, so that, Mr. Speaker, they have an undue advantage.
Okay.
Mr. Speaker, do you see the danger that I'm seeing?
Okay, Senator Murkomen. Senator Sakaja.
Chair, I'm very clear.
Order, Senator Sakaja.
Chair, I'm very clear.
Listen to the direction I want to give. We are discussing a bill, just like I stated in my earlier ruling. So stick to that.
Chair, I am discussing the bill, and I'm giving my opinion, which has also been expressed in a minority report. There is no majority report that was moved. That is not lost upon us. But I expressed my views on the bill in a minority report that is allowed in our standing orders. So, Mr. Speaker, is the direction that I don't refer to anything I said in the minority report. No one has said that I wish to move a minority report. But my opinions on the bill, on certain sections, and I'm going to quote the sections of the bill, are also expressed within the minority report. So I didn't stand, Senator Wetangula, I did not stand to say that I hereby want to move that this House adopts any report. The House is not adopting any report. The report by the chair of Justice Committee was tabled in the House to inform us. And it will be of value to members, and members have asked, I think a few members have asked before I've spoken, that they would also like to be informed on what the thinking was in the minority within the context of the bill, Mr. Speaker. So I don't think there's any need to prevaricate on that. And let me just go into it and why I took a different view on certain aspects, Mr. Speaker. And also, Mr. Speaker, I just want to point out, because somebody has said, I think it is Senator Kangata, that there are people who signed both reports. Mr. Speaker, that was guided, and if you look at the report, senators, where there's been a signature on the main report, and I'll give my example, we accept the entirety of the report with exception, and it is noted, there's a disclaimer, that apart from paragraph 557, we support the resolution to pass this bill, and we support every other finding of the committee with exception to that particular section, Mr. Speaker. And because of time, because I would go from clause 1 to the end, I think it is only efficient that I focus on the areas where I dissented on that position, Mr. Speaker. Mr. Speaker, Senator Ledama, there's a disclaimer. You need to look at it. The first issue, which I have taken issue with, and please advise my friend to stop debating with me on the floor, is that, Mr. Speaker, on the view regarding the proposed distribution of additional 70 constituencies among the counties, Mr. Speaker, I held that, and I still very emphatically and strongly hold that the pronouncement by the committee that the schedule is unconstitutional, Mr. Speaker, is really wrong. It goes too far. That it was not for us first to determine the constitutionality of it, Mr. Speaker, because, and Senator Wetangula raised a very important point yesterday, that by the time the Speaker has referred a bill to a committee, the Speaker has seen that it is unconstitutional. I mean, it is constitutional. We cannot be in this House processing something that we have all agreed then is unconstitutional, Mr. Speaker. But beyond that, Mr. Speaker, the issues raised, and I've heard the contributions, were really of a technical and drafting nature, but not of substance. Mr. Speaker, the essence of a popular initiative is the substance of the decision that Kenyans are being asked to take. That is the essence of a popular initiative. In fact, in 257 it says it could be in form of a general suggestion that then these houses are supposed to facilitate that Kenyan to draft it, or IBC to draft it into law. So if the intention of the Kenyan, Wanjiku, who has gone and collected signatures and gone to 24 counties is clear, you cannot say then that the suggestion is unconstitutional, Mr. Speaker. And I will explain, and I will give an opinion. Mr. Speaker, within the report, the committee has stated, and this is something that has happened in various different jurisdictions, that, Mr. Speaker, and I hold, that the power to amend a constitution is what we call constituted power, Mr. Speaker. Mr. Speaker, it is different from constituent power and is not the power to destroy the system created by a constitution. And I will explain. Parliament cannot usurp the sovereign power of an individual Kenyan or groups of Kenyans to actually exercise their sovereignty as per Article 1 of the Constitution, Mr. Speaker. Mr. Speaker, Article 1 of our Constitution is very clear. It says that all sovereign power belongs to the people, and the people can exercise it directly or in accordance with the Constitution, Mr. Speaker. Mr. Speaker, a plebiscite or a referendum is one of the events when the sovereign do what we call direct exercise of their sovereignty, Mr. Speaker. Mr. Speaker, there have been many different discussions of this, even in our country. If you look at the CKRC, the Constitution of Kenya Review Commission, in its final report, they stated that the purpose of including that Article 1 in our Constitution was to acknowledge the Constitution and the fact that ultimately the Constitution is a product of and must serve the aspirations of the people. Mr. Speaker, in Njoya versus Attorney General, the court considered that issue of constituent power, and it said that, and Justice Ringera, and I will quote him, Mr. Speaker, Justice Ringera said, the sovereignty of the people necessarily beckons that they have a constituent power, the power to constitute and or reconstitute, as the case may be, the framework of their government. That power is with the people. That power is a primordial one. Mr. Speaker, it is a basis for the creation of the Constitution, and it can therefore not be granted or referred to by the Constitution, Mr. Speaker. And finally, Professor Nwabwezi, Mr. Speaker, in his book, Ideas and Facts in Constitution Making, he summarizes what I'm calling constituent power as the authority to approve and adopt a constitution. And he says, the notion of the people as a constituent power is only an integral part of the wider concept of the people as a repository of the totality of a country's sovereignty, Mr. Speaker. Constituent power being the crowning point of sovereignty. So there's only one case that was referred to in this report, if you look at it. And that case that was referred to, where the issue of constitutionality arises, was a case in India. Mr. Speaker, in this case, which is Bharati versus State of Kerala, Minerva Mills Limited versus Union of India, the courts held, and that's another one, that and that's what the chairman is saying, that the courts can then declare later that this schedule is unconstitutional, but they held that they can only declare that amendment of the Constitution unconstitutional if it interferes with the basic structure of the Constitution. Meaning that the people, through a popular initiative, can decide to amend anything so long as they do not go to what we call the basic structure of our Constitution. Mr. Speaker, if you look at further to that, and the committee didn't note that, the doctrine of basic structure, the Supreme Court, again in the same jurisdiction, yeah, I think it was Justice Kana, he went over and even described what within a constitution is called basic structure. And basic structure of the Constitution, which cannot be amended, Mr. Speaker, and there's also the theory of unamendability, include areas like supremacy of the Constitution. You cannot collect signatures and go around the country and say that now you're passing an amendment to remove the supremacy of the Constitution. Number two, the rule of law. Number three, the principle of separation of powers. Number four, the objects and principles of a constitution. Number five, judicial review, things like federalism, devolution. Those are basic structure things. Mr. Speaker, Kenyans coming together from wherever to say that they want more constituencies and to say where they want it does not in any way touch the basic structure of our constitution and cannot therefore be stated to be unconstitutional, Mr. Speaker.
What's
Mr.
your
Speaker,
point of order, Senator Linturi?